Good afternoon, everyone, and welcome to today's webinar. Thank you very much for joining us. So as you're already aware, today we're going to be talking about redundancy. There will also be a short question and answer session at the end of the presentation as well for you. So firstly then, just to quickly introduce myself, my name's Hannah and I'm one of the HR advisors here within the Code team. So we're just going to have a quick look at the aims and objectives of today's session. So the aim of today's session is to increase your understanding of how to manage a redundancy process and to help you reduce tribunal costs by complying with employment legislation. Now, the objectives of today's session, they will be to discuss an overview of the law relating to redundancy, to highlight the risks of failing to follow employment law, and to explore how Code Total HR provides useful policies and template letters to help you comply with your legal obligations. So the learning outcomes from today's session, they'll be to avoid potentially costly mistakes relating to redundancy, to improve your understanding of the redundancy process, and to understand the legislation related to redundancy in a bit more detail. So in order to achieve these aims, objectives and learning outcomes, in today's session, we're going to be talking about, firstly, when does redundancy apply, how to identify the team members at risk of redundancy, the consultation process, notice and redundancy pay, redundancy and how that links with maternity leave, common mistakes that employers make, and finally how to minimise the risk of employment tribunal claims. So firstly then, let's take a look at when redundancy does apply. Now, redundancy is one of the 5 fair reasons for dismissal. However, in order for it to be fair, a fair process does have to be followed. Now, one of the reasons that redundancy could potentially be used is if you have a lower services demand. So, for example, you potentially have less patients within the practice, therefore you require less employees. It may also be that you've introduced some technology, and again, that technology means that you require less employees. Now, another reason for redundancy could be that maybe you've had a restructure within the practice, and that's resulted in the loss of roles. Another reason could be relocation of the practice. So maybe you've moved the practice to a different location and it's not feasible for your employees to relocate also. That again may result in redundancies. Now, a tendering situation can also result in redundancies. Now, with the tendering situation, it's usually as a result of a loss of a contract. Now, tendering is really complicated when it comes to redundancies. And the reason for that is you need to establish whether TUPE applies. If TUPE applies, or if TUPE doesn't apply, that will determine which practice is required to make those redundancies. So it is a really complex situation. So we'd recommend that if you're in that situation, you do seek some further advice on that. Now, another reason for redundancy could be the closure of the practice as well. Or finally, maybe it could be a cost-saving measure. So perhaps you have political or economic constraints within the practice that mean you have to make redundancies in order to make some cost savings. Now, it's really useful within all practices to have a redundancy policy as part of your staff handbook. It's useful to have it there ready for if you ever need it. That will help you with this process. So I'm going to quickly have a talk about when redundancy isn't applicable. Now, we've compiled this list based on reasons that we speak to members about on the helpline quite frequently. So redundancy wouldn't be applicable in a disciplinary, grievance, capability, or performance management situation. We often speak to members who perhaps want to use redundancy as an alternative for maybe following one of these processes, or maybe because they don't want to dismiss a team member for one of these reasons, they perhaps want to end that team member's employment on a more positive note. So we're looking to go down that redundancy route. Now, this isn't something we would recommend that you do. It is really risky, particularly from an unfair dismissal point of view. You're risking an unfair dismissal claim by not using redundancy for the correct reason. Now, a key to remember with the redundancy process is that you no longer require that role. That's why you're making a team member redundant. Therefore, you can't recruit to replace them either. So to give you an example, we recently had one of our members who they called us and had an issue, a performance issue with one of their team members who'd been with a practice for 25 years. They had a lot of service and they basically wanted to make them redundant because they didn't want to dismiss them for another reason because of that length of service and their loyalty to the practice. Now, we talked them through sort of really the risks there from that unfair dismissal point of view, particularly with that length of service as well, that only heightened that risk further. And we ended up sort of supporting them with that performance management process because it was a lot safer route. Once you've identified your redundancy process, the first step of the process is to identify the employees who are at risk of redundancy. Now, this would normally be done through a selection process that's based on the type of work that they complete. So, for example, your nurses or your receptionists. And the key with this is to focus on the role, not the individuals. So it's really important not to single out any team members there at all. So to give you an example again of a common issue we come across on the helpline is we'll have a practice call us that have negotiated a change with a dentist and they're concerned about the knock-on impact that that change is going to have to their reception team members or their nursing team members, that knock-on impact to their employees. Now in this situation, quite often they're looking maybe to make that nurse redundant because of that change. Now, with this, we would really recommend that you look at all your nurses, so you're not singling that one nurse out. Now, it's very unusual and it's very unlikely that your nurses will be contracted to work with one particular dentist. So you need to ensure that you're looking at all the nurses during that redundancy situation. Now, once you've identified all the employees who will be part of that redundancy process, who are at risk of redundancy, they're referred to as your pool of employees at risk of redundancy. Now, once you've identified those employees who are at risk of redundancy, the next stage is the consultation process. Now, this is really important because it is a legal requirement to consult with your employees who are at risk of redundancy. Now, if you end up in an employment tribunal can award a maximum of 90 days' pay to that employee purely for the failure to not consult with them. Now, that could be in addition to any unfair dismissal, discrimination, loss of earnings claim. So that is purely for the failure to consult. So it's really important to do this. Now, one of the things you can consider as part of that consultation process is voluntary redundancy. You can ask for volunteers for redundancy. Now, this can be really useful from a morale perspective because with any redundancy situation, it's very emotive. So that can help with that side of things. But also from a risk perspective for a practice, it can help reduce your risk. So having volunteers for redundancy, rather than you having to make compulsory redundancies, can help with your risk there. Now, what I'm going to focus on talking about today is that individual consultation process for redundancy. Now, that's when you're making 19 or fewer employees redundant. So that's what we find we speak to members about mostly on the helpline. But before I talk about that, I do want to make you aware of the collective consultation redundancy rules. So this is applicable when you're making 20 or more employees redundant. So if you're making between 20 and 99 employees redundant, you're required to consult for a minimum of 30 days. And if you're making 100 or more redundancies, you're required to consult for 45 days. You're also required to consult with either a trade union representative or an elected employee representative. Now, it's important that they're elected. So we'd recommend for this you go through a ballot process with your employees to nominate that employee who will be the elected employee rep during that consultation process. Now, that ballot is something that we can help our Total HR members with. We can provide you with the paperwork bespoke to your practice to help you with that ballot situation. Now, as I mentioned, I'm not going to go into a great deal of detail about these collective consultation rules because it's not going to be applicable for the majority of practices. However, if you are in the situation that you're looking to make 20 or more redundancies, please give us a call on the helpline and we can give you a bit more detail about this. So as I mentioned, I'm going to focus on those individual consultation meetings. So what we recommend for them is a basic 3-step process. Now, it's key to remember this is a basic process. Now, that first meeting would be an awareness meeting where you make the team members aware that the redundancy situation has arisen and the reasons that's arisen as well. Now, this can be a really emotive meeting. It can often come as a shock to some employees as well. So it's really important to be prepared for that. Now, to help with that, you can have a letter to give to all employees at the end of the meeting with a bit more detail, an overview of what you've discussed, for them to take away and to help them digest the situation. Now, once you've had that meeting, the next meeting would be your individual one-to-one meeting where you discuss specifically with that team member how it affects them. It's also their opportunity to ask you any questions they may have about the redundancy process. It's also their opportunity to raise any suggestions, alternatives that they may have to avoid a redundancy situation. But also during this meeting, you should be discussing with them the selection criteria that will be used to determine which employees will be made redundant and their individual scores. Now, the third meeting we recommend, that's your confirmation meeting. So where you confirm to the employees whether they will be made redundant or whether they will be remaining with the practice. You'll also be looking at a number of other factors, including suitable alternative employment for them. Now, as I mentioned just a moment ago, this really is a basic 3-step process. It may be that you need to have a number of meetings in addition to this to take into consideration any questions they have or any alternatives that they have raised. So it's important that you make sure that you are doing a thorough investigation and giving them that opportunity. Now, we would really recommend that you don't rush these consultation meetings. We find that if you're rushing them, that's when you make mistakes. So it's really important to ensure that you allow enough time to consult with your team members thoroughly. Now, I mentioned just a moment ago that at that second meeting, that one-to-one meeting with a team member, you should be discussing the selection criteria that will be used to identify the employees who are at risk of redundancy if you don't receive any volunteers for redundancy. Now, any selection criteria that's implemented, it should be objective and it should be fair. Now, it can be based on a number of different things. So, for example, skills, knowledge, experience, qualifications, disciplinary records. There's lots of different things that you can use for that. And for our total HR members, that's something we can help you create as well as that selection criteria and that documentation. Now, I would recommend that you do those ratings for that selection criteria based on maybe a sort of a scale, perhaps 1 to 10, where 1 is low and 10 is high. That will help you determine then the employees with the lower scores who will be made redundant. But it's important to ensure that any criteria that you use is fair and objective, as I've just mentioned, and you apply that. Now, when you have that one-to-one meeting with the team members and you go through the selection criteria that's used, they have the right to be able to see the ratings that you've given them. So we'd recommend that when you do those ratings, more than one manager rates that employee to help reduce any bias there. But it's also really useful to have some documentation to evidence why you've given that score. So it could be sort of appraisals, one-to-one meeting, copies of those disciplinary records that make sure you've got all that information on file so you can justify that selection criteria that you've given and those ratings that you've used, because your team members will have the opportunity to challenge that score. Now, there are a couple of risks with selection criteria to be aware of. Particularly the first one, a common myth is that it's really good to use first in, last out as your selection criteria. Now, this is something that you can use, but would recommend that it's not the only selection criteria that you use. You use it in addition to potentially other things. Now, the reason for that is your younger team members who physically aren't able to have the length of service of somebody else, there's a potential risk there with them for an age discrimination claim. Also, another common area is absence. Again, you can use absence as your selection criteria, but you need to ensure that any employees who have disabilities aren't being discriminated against a part of those ratings. So it's important to ensure that you're not rating them lower based on that disability, because that could warrant a disability discrimination claim. It's also really important to take into consideration any maternity or pregnancy related reasons when you're giving those ratings to the employees, again to ensure you're not discriminating against them. Now, once you've gone through that process of consultation with the employees, you've had that meeting to notify them of which roles are made redundant. At that final meeting, when you're confirming to the team members that their roles are redundant, you need to look at suitable alternative employment. Now, this is another employment legislation requirement. And I would really recommend that you don't assume that the team members aren't interested in that role, just maybe because perhaps it's a different role to what they're currently doing, maybe the salary is slightly less. It's always better to give them all the vacancies that you have for them to make their own decision of whether it is suitable for them or not. If you're a group of practices, multi-site, you may also need to consider relocation. So if you've got any vacancies or any alternative employment at another practice, give them that opportunity there as well. You can also agree a trial period for this suitable alternative employment. So that can be up to 4 weeks as well. And during that 4-week trial period, if either party deems that the role isn't suitable for them, you can come to the agreement that they would be made redundant still, but they would still retain that right to redundancy pay. So you can implement that trial period as well. Now, there is slight differences when it comes to suitable alternative employment for team members who are on maternity leave. Now, if you're making any team members who are on maternity leave redundant, they have automatic priority for that suitable alternative employment. They are the priority when you're offering that suitable alternative employment, so you need to consider them first above all the other team members. And that's really one of the key differences with employees who are on maternity leave. Now, unfortunately, if you go through this process, you consult with them, you implement that selection criteria, and you can't find any suitable alternative employment, you may be in this position that you have to dismiss the team members. Now, it's really important to ensure that this is a last resort. You have looked at all other alternatives available to you. Now, when you go through the whole consultation process, right from the beginning, but particularly throughout the dismissal meetings, it's really important to remember that the team members have the right to be accompanied. Now, they have the right to be accompanied by either another employee or a trade union representative. But because it's a particularly emotive time for them, quite often they can want to be accompanied by a family member. And although they have no legal right to this, there's been a lot of case law recently where employers have been deemed unreasonable by refusing employees being accompanied by someone outside of that trade union and employee bracket. So we'd really recommend that you do take that into consideration when you are going through that process. If they ask to be accompanied by someone else, really recommend that you try and consider that and agree to it where you can. And if you are in the situation where maybe you are thinking that you might refuse that right to be accompanied, would really recommend that you seek some advice purely to sort of help mitigate that risk there for you. Also, when you're dismissing a team member, for any reason, they're entitled to a written outcome of confirmation of that dismissal. Now, in that written outcome, it should confirm the reason for the dismissal. So in this case, it would be redundancy. They're also entitled to the right to appeal that decision and would recommend in that written outcome you document that right to appeal as well. Now, ideally, that appeal should be held by someone impartial and not previously involved in the case. Now, I appreciate for small practices that is really difficult. It's not always possible to have someone that hasn't been involved in that redundancy process. So again, it might be worth considering getting some expert advice on that, maybe considering if there's someone external that can support you with that appeal, really again to try and mitigate that risk where you can. Now, when you're making team members redundant, they're entitled to redundancy pay if they have a minimum of 2 years service. Now, the redundancy pay is also capped at a maximum of 20 years service. And that's the current statutory maximum payout for redundancy is £15,750. Now, as I just mentioned, this is the statutory pay. Some employees may be entitled to enhanced redundancy pay. So before you make these calculations, check their terms and conditions of employment. See if they've got a contractual right to enhanced redundancy pay. That should be detailed in their contract if it is. It's quite likely to be applicable maybe for employees who perhaps have been with the practice for a long time, or maybe if you're taking the practice over by TUPE as well, they may have had it in their previous terms and conditions of employment. It's always important to double check that. Now, if they are entitled to either statutory or enhanced, any redundancy pay under £30,000 isn't taxable. But it's important to remember that there is no age limit on for redundancy pay to be paid. Now, looking at the statutory redundancy pay, it's calculated based on a number of different factors. So for every year that the employee is employed and they're under the age of 22, they're entitled to half a week's pay. For every year that they're employed between the age of 22 but under 41, they're entitled to 1 week's pay. And for every year that they're employed age 41 or over, they're entitled to 1.5 weeks' pay. So that would be the calculation that you used for that statutory redundancy pay. And again, for our total HR members, it's something we can help you calculate as well. When you're making an employee redundant as well, they're also entitled to a notice period. Now, this would be their contractual notice period, so what's detailed in their terms and conditions of employment. But it's important to ensure the contractual notice period is equivalent to or more than the statutory minimum notice period. So that's the minimum notice period you're legally required to give. Now, that would be for up to 2 years of employment, 1 week's notice. And after 2 years' employment, up to a maximum of 12 years, that's 1 week for each year of employment. So check that contractual notice period is equivalent to or more than that statutory minimum notice period. Now, you don't have to ask that team member to work that notice period. You can pay them in lieu of that notice period if it's more suitable for the practice. But unlike redundancy pay, any notice pay or holiday pay is still taxable in a redundancy situation. Now, I've talked a lot about the risks during a redundancy process, as with any dismissal process, and the potential risk of maybe a tribunal claim. So it's really important to make sure you keep records of all meetings that you've had with employees, any letters and correspondence you sent to them, the selection criteria used, the ratings you've given to the team members. That will help you if the team member challenges that decision. So maybe they appeal that decision, or maybe they take you to an employment tribunal. You rely on those records to defend any decisions that you've made. So it's really important to ensure you keep them and you hold them confidentially as well, in line with GDPR. So we're just going to talk about some common mistakes that we find employers make. So these are things that we've come across on the Code Total HR helpline. So the first one has got to be that it's not a genuine redundancy situation. So that would go back to what I was talking about at the beginning of the presentation, where maybe an employer is trying to use it as an alternative to perhaps a dismissal, a disciplinary process. Another common mistake we come across is identifying the employees who are at risk of redundancy. So again, that would come back to maybe singling out a particular team member. Another really common mistake is forgetting to consult with your team members, not consulting. And as I mentioned earlier, there is a potential payout for that as well. Another common mistake is an unfair selection process. So that could be using discriminatory reasons for your criteria for your selection. Another key one is not offering suitable alternative employment, particularly to your employees who are on maternity leave. So forgetting to prioritise them or forgetting to offer it at all. It's really important that you consider that. Now, something else that's often commonly forgotten is forgetting to offer reasonable time off to employees. So when an employee has been confirmed that they're being made redundant, they're entitled to reasonable time off. Now, that reasonable time off is to attend interviews for other jobs, training purposes for future employment as well. Now, there is no legal definition of what is reasonable, so it's really important that you try and accommodate it wherever you can, because if an employee were to challenge it, the definition of reasonable will be determined by that employment tribunal as to whether you have acted reasonably or not. So if you are ever in the situation that you're considering refusing that reasonable time off, I'd really recommend again you seek some advice to mitigate that risk, because there is sort of a grey area there as such. So that links in nicely really to the risks, and I have mentioned this a lot, but as with any dismissal process, there is a lot of risks involved. And your top one that I want to talk about first is your discrimination risk. Now, with discrimination, your team members don't have to have any length of service to be able to claim discrimination. And there's also no cap on the amount of money that an employment tribunal can award for a discrimination claim. So that could be for things like your links to pregnancy, maternity, age discrimination, disability discrimination, quite often linked to your selection criteria as well. Now, another common claim that employment tribunals have in relation to redundancy is that unfair dismissal claim. Now, that's quite often in relation to not consulting with your team members, or maybe the redundancy situation isn't even genuine. So that's quite often linked to a failure to follow the ACAS guidelines as well. Another common risk is a breach of TUPE guidelines. So this comes back to the tender situation I was talking about at the beginning of the presentation. Now, tendering is a genuine reason for redundancy. However, if you haven't correctly identified whether TUPE applies, and then which employer then is subsequently required to make those redundancies, if that's done incorrectly, you could be in breach of TUPE guidelines there as well. Another potential risk is a grievance situation. So if your employees don't feel like the redundancy situation and process has been handled correctly, they can submit a grievance about that. Now, quite often grievances take around about 3 to 4 months sometimes to resolve. So it's quite time consuming, and really from a morale perspective, that can be detrimental to the practice. And in addition to that redundancy situation, it can be really detrimental there. So we try and recommend you follow that correct process to reduce any risk of grievance being submitted. Now, also, we find from a practice point of view that retention can be an issue. So when you're making redundancies, and not just the people that are at risk of redundancy, the whole practice, there can be a feeling of lack of a job security. So we do often find that when you're making redundancies, it can often result in resignations from other team members. So in addition to those employees you're making redundant, you can receive a number of resignations. So it's really important to try and support all employees in the practice throughout the redundancy process to try and avoid those additional resignations as well. Now that ties nicely in with work-related stress. Again, we often find our employees who remain within the practice, they can feel stressed, again because of that lack of job security, but maybe they also have a bit of an additional workload. So that can add to that work-related stress. It's really important to try and support everybody through that process. Now, another key risk to make you aware of is your apprentices. Your apprentices have additional protection when it comes to a redundancy process. So to give you a recent example of a case law, it's Kinnear versus Marley Alternate Limited. Marley Alternate Limited made Kinnear redundant. Kinnear was an apprentice. Kinnear then took Marley Alternate Limited to an employment tribunal. They were successful at that employment tribunal and won £25,000 at that employment tribunal. And that was on the basis that when Marley Alternate Limited took Kinnear on, they agreed to that apprenticeship and to train them to have the skills to be able to fulfill that role. But because they made them redundant, they didn't give them those skills that they required. Therefore, there was an issue with sort of alternative employment for Kinnear. And that £25,000 was based roughly on the remainder of money for the rest of their apprenticeship. So it is really important when you're going through a redundancy situation to take into consideration your apprentices as well, because there are additional risks involved. So if you do find yourselves in a situation that you've made employees redundant and they're potentially looking to initiate that employment tribunal process, there is timescales for them to be able to do that. So it's 3 months less 1 day following them leaving the practice that they have to submit that employment tribunal claim. But prior to that employment tribunal, both parties will have the opportunity to participate in ACAS early conciliation. Now, this process lasts around about a month, but a 2-week extension can sometimes be agreed. And that's where both parties have the opportunity to try and come to an agreement outside that tribunal setting as to maybe the monetary value in the settlement for that dispute there. But if you do find that you're unable to come to that agreement, you can agree outside of that month time frame. However, at the same time, you may also be preparing for that employment tribunal as well. Now, if you can't come to an agreement and you end up at that employment tribunal, what the employment tribunal will be looking for is, and they really decide whether you have been fair or reasonable. That's what they'll be assessing as part of that employment tribunal, whether the employer has acted fairly and reasonably in the circumstances. Now, as I mentioned just a moment ago, one of the common things in terms of a redundancy at an employment tribunal is an unfair dismissal claim. Now, the maximum payment for an unfair dismissal claim is £86,444. So it is really risky there from that perspective. So really recommend you do seek some advice and make sure you follow that correct process. So to make you aware of some potential employment law updates that will be coming into effect that are going to affect the redundancy process. Now, there's currently a bill going through Parliament, and the proposal is to change the legislation regarding pregnancy and maternity for redundancy. Now, the proposal is that the protection for employees who are on maternity leave is extended, and that's extended until from when they notify employer of their pregnancy through to 6 months after they return from maternity leave. So that's the current proposal. It hasn't been decided yet. It is going through Parliament, but it is something we're keeping sort of an eye out for within the Code HR team to see what the final decision is. To also make you aware, as part of the Good Work Plan and the 51 changes that are coming into effect, one of those changes is about the break in employment that affects continuous service. So currently that break in employment for continuous service is 1 week. That's being extended to 4 weeks. So that's another change to be aware of from a redundancy perspective. So as always, we've got a number of different templates and documents that you can use on iComply to support you with this process. So one of them would be the redundancy policies I mentioned at the beginning. We've also got your maternity leave and pay policy as well. We've also got the staff terms and conditions of employment and dental nurse apprenticeship terms and conditions of employment there. From a discrimination point of view, we've got a few documents as well. So we've got the Equality, Dignity and Human Rights Policy, the Human Rights Act and Equality Act, and the Disability Rights under the Equality Act document as well. Now, appreciate with the redundancy, there isn't loads of documents on iComply, and really the reason for that is that they're so bespoke to each individual. It depends on the individual's role, length of service, as to those documents, so it's really difficult to provide template documents for you. So for our total HR members, if you're in a redundancy situation, please let us know because we can support you with doing those individual letters for your team members as well. We can help you create them. We can also help you with things like the selection criteria as well. So to make you aware of some recommended actions really for you for next week to make sure you're prepared if you do end up in a redundancy situation. So make sure your redundancy policy is up to date. It's always better to have that as part of your standard staff handbook, so it's there if you need it, rather than having to introduce one when you do need it. So that's why we have that one on iComply there for you. Also check that your maternity leave and pay policy is up to date as well. And finally check your Equality, Dignity and Human Rights Act. Would also recommend that you check you've got signed terms and conditions of employment on file. Now this isn't just from a CQC perspective because it is something we are aware that CQC may look to check, but also from a redundancy perspective, you will need to rely on these to be able to make your redundancy pay calculations. You'll rely on them to understand what notice the employee is required to have as well. So it's important to have them on file. Would also recommend that you check you've got signed job descriptions on file as well. So these are really useful when you're identifying your pool of employees that are at risk of redundancy. So that will help you to find their roles within the practice. So I know I've talked a lot about risk today and how that links with the dismissal process. And that's really why we've set up the Total HR service, because what we focus on is prevention rather than cure. So as part of the Total HR service, you'll receive personal support with the setup of your staff handbook and contracts for your practice. And that's for both your employed and your self-employed team members as well. We'll also review those documents on an annual basis to ensure they're up to date and complying with any changes to employment legislation as well. You'll also receive advanced HR templates and unlimited access to your designated Code HR advisor with editing support. So that's really useful during your redundancy process when you've got lots of individual and bespoke communication to produce. You'll also have access to a web application, so that will help you manage staff holiday, training, sickness as well, and you can also store documents on there. So if you're not one of our Total HR members that have joined us today and you are interested in the Total HR service, please get in contact with us and we can arrange a free demonstration and chat for you.